Thank you for joining. Good afternoon, everybody. Thank you for joining today's webinar. It's going to be presented by Steve Braten at Rosenbaum PLLC. But before we get started, we're going to do some housekeeping. Catie Phillips will be the moderator for this class, and she'll be joining this after we introduce all of our sponsors for today. But if you would please put all of your comments or questions in the Q&A section, not in the chat, as the Q&A will be recorded. And if the questions aren't gotten to during the time of this class, Steve and or Catie will get back to you after. But if they're in the chat, there's a good possibility that they could be overlooked. So putting these classes together would not be easily done without the efforts of our sponsors. So we're going to start with Vinteum software. I believe that Laura does the introduction. So Laura Maligan, I'm
Yes.
going to introduce you.
Thank you so much. Hi, everyone. My name is Laura. I'm the sales executive here at Vinteum. We specialize on providing services and software for residential management, meaning HOAs, condominiums, cooperatives, also property management companies or property managers as well. Today, we will hear all about the new legal changes that happened this year, and some of them are soon to be in full effect, like Florida's website law that requires associations with 25 or more units to have a website with a private residence portal to store all important documents, communications, your meetings, recordings, transcripts, etc. The deadline for this compliance is actually in 19 days, but maybe if some of you have not yet, take in charge of that, you don't have to worry because Vinteum has you covered. We build the website and set up the residence portal for you, making sure your community is organized and compliant without the stress of doing this all by your own. If that sounds like something you'd be interested, I'll be sending you our information on the chat, where you can schedule a call with me, and get your community website and portal going with Vinteum. So we will be sending the information through the chat. And yes, that will be all for today. Thank you so much.
Thanks, Laura. Next, we're going to move on to Sandeep J from J.R. Fraser. How are you today?
Yeah, I'm doing fine. Thank you. Thank you. Thank you, Jamie. I'm with J.R. Fraser. We do all kinds of reserve studies from condos to HOAs to commercial buildings. And we also do insurance property valuation reports. And our company's been around for quite a while. More than the services we offer, the other thing is if anyone, whether you're using our services or not, and you feel like you have a question that you don't have an answer to, you guys are always welcome to call us. It probably will be me who answers the phone, not answers the phone, but I'll be the one responding. But we just like to inform people of everything that's going on in the marketplace today, but also just educating people. So if you have any questions, don't worry, just call us. If you use our services, you can always call us. But even if you haven't and you had a question or two, we are here for you guys. Okay? Have a wonderful day, everyone.
Thank you. Next, we're going to move on to Shawnee Haas from Munyon Painting. Good afternoon, Shawnee. How are you today?
I'm doing good. How are you?
I'm good.
I'm Shawnee from Onion Painting. I'm the marketing manager. We are a third generation owned painting company that covers all of Florida. We offer interior and exterior painting services as well as pressure washing that in order to keep communities looking beautiful and well kept. If you right now we're doing free estimates. We know everybody is just finishing up their budgeting season, so if you're planning some projects for next year, feel free to reach out to me and I'll go ahead and get some estimates set up for you. And happy holidays.
Happy holidays, Shawnee. Thank you. Next, we have Dahlia Anise with Estate Planning. Good afternoon, Dahlia.
Good afternoon. Thank you, Jamie. My name is Dahlia Anise. I'm an estate planning attorney with Legacy Life Plan. So I do wills, trusts, and capacity planning children's protection plan, and so forth. When people think about estate planning, they just think about, yes, I want to give my assets to my, my spouse or my children, but it's really a lot deeper than that. It's estimated that within the next 25 years, between 85 and $125 trillion are going to pass from baby boomers to millennials, Gen X, Gen Zs. And also, it's known that 90% of inherited money is gone by the second generation. So a lot of people worked hard for their assets, for acquiring wealth, and all of a sudden it's going to pass to the next generation, and the next generation doesn't know how to keep it. But with a thoughtful estate plan and creativity, and this is what I'm going to be focusing on with my clients next year, is how to preserve generational wealth within your family through estate planning, through the proper estate planning channels. If this is something that resonates with you and you have more questions, I'd be happy to answer your questions. I'm going to put in the chat a link to schedule a discovery call with me. So please feel free to click on that. If the times that you see don't work with you, I'm also going to be putting my email address. Just email me and we can schedule a time to talk. And I wish you all a happy holidays.
Thank you, Dahlia. Next, we're going to go on to Dylan Pena from PD Concrete. Hi, Dylan. How are you today?
Thank you very much for the introduction, Jamie. So my name is Dylan Pena. I'm the business developer for PD Concrete Specialist. We've been serving South Florida for over 21 years now. We're licensed, insured, and locally owned in the South Florida region. We have 2 offices, with one in Aventura and one in West Palm Beach. Most importantly, though, we provide concrete restoration services, waterproofing, post-tension cable repair, and we also assist with the recertification process to ensure your property remains compliant with the law. Now, lastly, we do not use subcontractors. We have an in-house repair team to do all the repair work to ensure accountability and quality work for every step of the way. If you have any questions, I'll leave my information in the chat box below. Thank you very much, Jamie, and happy holidays.
Thank you. Happy holidays to you too. Next, Ruthie Engel from Kaiser Air Conditioning. Welcome, Ruthie.
Hi, thank you so much for the intro, Jamie. I appreciate you. I am the Director of Marketing here at Kaiser Air Conditioning. We are locally owned and operated and have been serving South Florida, including Broward, Palm Beach, Martin, and St. Lucie counties for 20 plus years. So we are obviously trusted by the community, being in business for so long. And just know that with local ownership comes local accountability. You will always have someone here that you can connect with personally, one-on-one. If you ever have any emergencies, if you have any specific concerns, I can address those with you head on and make sure that you're always getting VIP service. If you have a resident on your property that does get referred to us, we will incentivize you for those referrals. So please be sure to send them my way. And lastly, just for your residents and for your communities, we are doing a special offer on a water heater flush, especially for properties that are, or properties that have water heaters that are 10 years or older. You definitely want to make sure that the water heaters are performing optimally so that you can have those hot showers. A cold shower isn't fun for anyone in these cooler days. We're Floridians. We cannot handle it. Okay. So that special is just for you and your residents. Reach out to me if you have anybody that's interested in scheduling that. And again, we'll make sure that they get right in and get the best service possible. That's a lot. Thank you. Happy holidays, everyone. And I'll drop my information in the chat box. Thank you so much.
Thanks, Ruthie. And now up we have Siobhan Gonzalez from our favorite engineering firm. Siobhan, can you tell us about your firm?
Oh, Jamie, thank you so much. Yes, happy holidays, everyone. I cannot believe this is the last webinar of the year. I can't believe that we're closing out 2025. This is wonderful. Happy to be here. I am the business developer here at United Professional Engineering. We have been in business serving South Florida and condominiums for over 20 years. So our team is trained, licensed, and we specialize in all things condominium inspections, concrete restoration, repairs, pool decks. I mean, from the roof to the pool, we're here to serve you. Also, including reserve studies. We understand that this time of year, the deadlines certainly came faster, I think, than anyone anticipated. But we are here and we're able to serve. So if you have a question regarding your association, deadlines, compliance, where you're at, we understand that every project is unique, has its challenges, but our commitment is we are with you start to finish to navigate the best decision for you and your association. So reach out to me, enjoy the webinar, and I look forward to meeting you soon.
Thanks, Siobhan. Nice to see you.
Nice to see
We
you.
do have a couple of service providers that weren't able to attend today. So honorable mention to Faster IO, City Quiet, Best Roofing, The Paving Lady, COA Solutions, Southwest Elevators, Hafer Company, and Velocity. All of their contact information will be sent out by Peggy at the end of this class. And just to introduce myself, I'm Jamie Gelfand with First Citizens Bank. At First Citizens, I work in the CAB, Community Association Bank Division. We service HOAs, condos, and co-ops to provide loans, lockbox, FDIC protection on funds. We integrate with over 20 software through API integration. So if I can assist you with any of your banking needs, my information will also be in the chat. And now we want to introduce Catie Phillips from Rosenbaum PLLC, who's going to take over as moderator. Hey, Catie.
Hi. So I'm actually on Steve's because we're here in the same room, but I'm going to be moderating all the Q&A, and I have already been answering some of your questions. I'm Catie Phillips with Rosenbaum PLLC. We are a full-service law firm with offices in West Palm Beach and Stewart. We are here for all of your legal needs, including your general legal matters, contract review, document amendments, collections, all that good stuff. We do everything in-house, including litigation, so only one-stop shop. And Steve is our shareholder of the Community Association Division. He runs this division where we have over 6 attorneys that work in the division in some sort of capacity or another. He's going to be doing the legal update for you all today, and I will be here answering questions. Don't be shy, ask your questions, and if it's relevant to the topic that we're on, I will actually speak out the questions to Steve. If it's not, we'll try to get those done in writing to you. And if for some reason we miss your questions, please feel free to email us afterward. We will be sending a copy of the slide presentation to everybody who attended. And with that, I'm going to go ahead and share that presentation and let us go ahead and get started. So thank you all again. And we're going to go ahead and get started here. So let me get this going for Steve. And yeah, I'm going to get rid of the bar. And then you want just your little window?
Yeah.
Okay. 1 second. Couple just little technical things, and we're going to get going. All right. Here we go.
All right. Well, good afternoon, everybody. Thank you for having me today. It's always great to be part of this group. We have a lot of experienced professionals who we heard from today. And of course, Jamie, thank you for the introduction. We're going to get into the legal update for the 2025-2026 legislative cycle here. Hopefully this will actually move the screen. There's some of our lawyers in our practice group. And so the first thing we're going to talk about briefly is some of the changes to the My Florida Home program that was initially put into place in 2024. It was a pilot program to offer some grant funding for certain components of your condominium buildings if you were eligible to replace. There were some limits on eligibility. You had to be at least 3 or more stories in height, and then only associations that had complied with their milestone inspection and integrity reserve studies were eligible to apply. The big change that happened with the last legislative cycle was to reduce the threshold vote needed to obtain the grant money. So this was a two-step process. We needed a board vote to apply for the funds. If the grant was approved, then you had to have a 100% vote of the membership in the building impacted, which was really not attainable. They reduced that threshold to 75%, which is still a pretty high bar. So not sure how many communities, condo associations can qualify for these grants and how much money's left.
It's closed for
It's
this
already
year. But
closed.
what I
Okay.
would suggest to everybody is to go to the website, the My Safe Florida Condo Pilot Program, and get on the email list so that when it drops again next year, because they ran out of money within a month.
Okay.
So you got to apply like
gotta
on
be
the
quick.
first day if you're interested in trying to do this in 2026.
Got it. Also, in terms of the components that we're talking about here, the grant is limited in terms of the components. You have your roof. Also, when it comes to hurricane mitigation, if you're trying to get your windows and sliding glass doors replaced, they have to be common elements of the association, which most condominiums, the windows and doors are part of the unit. They may not be common elements, so you need to talk to your association lawyer about that. And you also want to understand what's the caps on the components, how much grant money will you be eligible for, so you can do a cost benefit analysis of the efforts to go through the application process. This kind of gives you an overview of how much, the grant matches $1. You'll get $2 from the state, but again, there's a total cap on the maximum dollars you can get, not to exceed $175,000. Okay, going into House Bill 913, those of you who are familiar with the bill, the introduction to the bill was about 24 or 25 pages. I think the bill in total was about 194, 195 pages, somewhere in there. A lot of changes that were made, a lot of updates trying to soften the impact of the Sears studies and the milestone inspections that were first implemented, I guess, 2 legislative cycles ago after we had the collapse at Surfside in Miami. Before we get into those changes, we're going to talk about some changes that were made to Section 468 that governs our community association managers and our CAM firms. There's been some changes to licensing. One, if a CAM has had their license revoked, they're not eligible to reapply for a 10-year period, which is a very serious change in penalty. Also, the statute requires that CAMs must maintain an online account with the department, and there's certain requirements that they have to disclose to the department in terms of employment, etc. Okay, so if the DBPR suspends or revokes a CAM license, written notice must be provided to the CAM firm and the association where the CAM works. Also, CAMs and CAM firms may not knowingly carry out a direction from the board of directors that violates a state or federal law. Obviously, if you have a concern about a board's direction to you as a CAM, you should seek out, consult with your firm. If you're an independent, you may need to get independent legal advice, because association attorneys can't also represent the CAM or the CAM firm. There's a new requirement for CAM contracts that has to be in 12-point font, that states that the community association manager shall abide by all professional and record-keeping requirements imposed by Part 8 of Chapter 468, which governs CAMs and CAM firms. And CAMs must attend at least one board meeting or member meeting per year. And if requested, the management contract has to be provided to the member who's requesting a copy.
Now, Steve, would that apply to individual contracts with managers, not just a management company?
The disclosure?
The disclosure of the contracts for community association management must include the 12-point font.
Since it's directed, it says the community association manager shall abide. I would say it should. Yes. Okay. Going on, there was some changes to the conflict of interest provisions in 468. We have the section there. Certain disclosures are required. If there's an intent on submitting proposals or contracts for non-management related work, if that work exceeds $2,500, it has to be disclosed in the contract. And there's certain requirement for the board to approve that contract. There's disclosures that have to go into the minutes, which we didn't have on the slide here. Also, if it's not disclosed, the board can vote to void the contract. The 20% owner approval, that's not in the statute. We'll have to get that corrected. But the point is that the board can vote to void a contract if the proper disclosures are not provided from the management firm in the contract. So many of you have seen updated management agreements that supplemented disclosures that weren't there before, after this went into effect. If the board proposes to engage in any activity that creates a conflict, we have to have notice of the meeting at which the proposed activity will be considered, the description of the activity, disclosure of the potential conflict, and a copy of all related contracts and transactional documents available to the membership. Okay, so let's get into the milestone inspections, some changes here some of you may already be familiar with. The legislature clarified that we're talking about 3 or more habitable stories to be required to have a milestone inspection, and that habitable refers to spaces suitable for human occupancy. So, to the extent that that was a question, that has been eliminated. It specifically excludes garages, hallways, storage closets. So if you have a building that's above a garage, you don't count the garage level to figure out whether you are required to have a milestone. The other thing, again, having to do with disclosures, it requires any professional who's going to bid on work that's covered in the milestone report, meaning if the milestone report identifies repairs that need to be performed, if the design professional, engineer, architect, or whoever intends to also bid on overseeing that work, that needs to be disclosed up front. And then
So I think let's pause on that for a minute
Sure.
because there's been some confusion. There. So if they're using the engineer to do the milestone inspection and the SIRS report, can they still use the same engineer to do their projects?
Yes.
Okay.
Yeah, it just needs to be disclosed by the engineer that they intend to oversee that project, and it should be noted they prepared the report. I mean, look, at the end of the day, these folks still have a professional license and are accountable. So, for them to recommend work solely for the purpose of overseeing that work, would be risky for them. Okay. Structural integrity reserve studies, again, only has to be done for buildings with 3 or more habitable stories. The deadline to complete SEERS was pushed back to December 31st, 25 from December 31, 24. And recognize that while the SEERS report focuses on the components of your building that provide structural, that has something to do with the structural integrity of the building, you still need to have a reserve study on the non-SEERS components of your building. You still have a duty to fund those non-SEERS components in addition to the SEERS components. The only difference being is your membership still has the opportunity, if presented by the board, to partially fund or waive the funding of non-SEERS items versus SEERS has to be funded, okay? The other significant change that was made to 718.112 is actually a specific reference to the pooled method of accounting for SEERS reserves and non-SEERS reserves, for that matter. Prior to this legislative change, there was no reference in 718 to the pooled method of accounting for your reserve components. That was only in the Florida Administrative Code. Also, the statute makes clear that the board, not the membership, but the board can vote to change the accounting method being used by the association to go from straight line to pooled or vice versa. So the question becomes, okay, so we've been funding our reserves based on the straight line accounting method for the last 10 years. Can we convert those reserves to the pooled accounting method by a simple board vote, or do we need to go back to our membership and ask for a membership vote? The more conservative approach would be to have the members vote And the reason being is somewhere else in 718.112, it says reserves are not supposed to be used for an item they weren't intended to be used for. So that becomes the rub. I mean, again, we're just talking about an accounting method versus spending, but at the same time, caution would dictate until they clarify this maybe next year to get that member vote if you're going to consolidate your existing reserves into a pooled account on a go-forward basis and then of course, you need to keep separate, and the statute expressly states this, you need to keep your Sears reserve fund separate from your non-Sears reserve fund. And
Separate bank account.
separate bank accounts. They cannot be commingled. Okay.
Steve, that board vote requirement just for the changing from streamline to pooled, is that just SERS or is that both SERS and non-SERS?
It's for both.
Okay.
Yeah, I think it's for both. Yeah. Okay, so now we get into some other things that they did in this statute that are some of it useful, perhaps some of it not so useful. Maybe some of it needs to be clarified again. But one of the things it talks about in the statute is reserves may be funded using other methods such as a loan or line of credit. However, this requires a majority vote of the membership. And then the other part, excuse me, that gets a little more complicated is that if you are going to go to a loan or line of credit, the statute says that the line of credit or the loan must be sufficient to fund the entirety of your Sears reserve and be immediately available to draw or required for maintenance or repairs. So that seems to be a threshold that for communities where they're significantly underfunded may not be a realistic option. So just caution there. And then when we look at what now constitutes a reserve item since the July 1, 2025 legislation, they bumped the threshold from 10,000 to 25,000. So if an item costs under 25,000, it no longer falls into the reserve study. The question may come up, well, should we still continue to reserve for those items? Well, then it becomes discretionary. And if your budget goes up over the 15% threshold from the prior year, you're going to have to propose an alternative budget to the membership. So it gets very complicated. So the simplest way to approach this is stick with the threshold that they've established, and that begins February 1, 2026. That's important. Also, the statute does say that between the time you get your study and as you move forward, if you get better data, you want to adjust for inflation, you can adjust your numbers. The board has the discretion to do that as long as it's got a basis for doing so. You can't just decide. It needs to be based on either a better estimate or an inflation factor or something like that. One of the other changes that was significant is it gave the membership the opportunity to vote to pause reserve funding under two scenarios.
Including SERS.
Including SERS, right, including SERS. The first one is a little bit simpler, and that is if the building is determined to be uninhabitable due to a natural disaster, the board may pause funding until you can get the building back to habitable status, okay? Because you're likely going to have to levy a special assessment in that scenario. The second one is a little bit more difficult, and that, of course, the legislature creates a formula we have to decipher here. And it says for budgets adopted before 12/31/28, as long as your milestone inspection has been completed within the last 2 years, and the statute actually says calendar years, the majority of the membership of the association may vote to pause or reduce Sears funding for up to 2 annual budgets. If the reserves are completely paused, the Sears report must be done before continuation of reserve funding. So the thought process here is, number one, when was your milestone inspection report done? Okay, so if we're sitting here and you're looking to do this in 26, you have to go back 2 calendar years. If your milestone is outside of 2024, you wouldn't be eligible to take advantage of this. And then also, it's limited to the work that needs to be done pursuant to that milestone inspection. So if your milestone inspection report didn't call for any work to be done to the building, then we're not eligible to pause under this process. So you have to be doing work pursuant to the milestone as pursuant to either your milestone or your Sears. If they had made it both and your asset had gotten to zero life, you might have been in a better position. They chose not to do that.
Yeah, let's clarify this, right? So if they're at 1 year left on concrete and they're working on the plan to do the concrete,
Mhm.
they can vote the people to waive the funding of that since they're going to do a special assessment.
Yes. Well, no, they can vote to say that again. Just on that one component, if they're going to specially assess,
They
right?
could special assess because they're doing the
Right,
project.
right.
That's
Then they don't
gonna
have to,
affect the-
right. So the whole point is, there's a difference between pausing all your funding versus pausing a component because you now have to do the work on the component. If the board's going to do concrete restoration, in 2026, I don't think we need to be funding, concrete repairs in the reserve, in the budget for
Yeah.
26, because the assets at zero useful life. So that's pretty that's complicated. Reach out to your association lawyer, make sure you're following the right path there. And I would certainly bring in, your reserve study specialist, like a J.R. Fraser to consult when you're going down these roads here. Okay.
And the important takeaway there too is if you do pause it, you do have to do the SERS report over.
Absolutely.
The whole SERS report.
The whole SERS
the-
report.
The item that was
Right.
paused.
Right. Okay, we
And
talked about
actually,
that.
there is a question now. What is the time frame that the SERS report is good for? How long is it till they have to get another
I
one?
think it's 3 years.
3 years.
3 years. So it should be updated every 3 years. Okay. We talked about the non-commingling of Sears and non-Sears reserve funds. So we're going to move on to budgets unless there's any more questions about um, the changes to the Sears and non-Sears.
Stephen, can you reconfirm that if the board votes on switching from the straight line to the pool of funds method, that the existing reserve funds that were previously allocated to roofing, painting, elevators, etc., then must still stay in those specific accounts until used up by the association?
I think that what I said is that the most conservative approach would be to have a member vote to move them into the pooled accounts versus the board vote. I think the way the statute is written, it could go either way because, like I said, the statute never mentioned the pooled method of accounting in the statute, and here we now have a provision that gives express authority to the board to change the accounting method. So, lawyers are going to disagree on what's the best way to approach that. The safest way to approach it is have a member vote. But there's an argument to be made that you don't need the member vote because you've got the authority in the statute.
And remember, that's only for the items that are in the structural reserve. It can't be used for anything else. If it's pooled, it could be used fluidly over those categories, the structure, the painting, the plumbing, the roofing, but it can't be used for any other items other than that's in the SERS
Without a
pool,
doubt.
right?
Yeah, you have to use it for what's in the pool. And
Right.
so you have to have two separate pools for sure, non-Sears and Sears. And so, your non-Sears items you can use for those, and then the Sears items, the funds can be used for those. So even when you get into this consolidation, you need to make sure the money is getting directed in the right directions. And so that does involve consulting whoever did your Sears analysis for you to make sure whatever money you're going to move into a pooled account is the correct funds.
And just to give you guys a little bit of like side insight on that, if you do utilize money in a pool for another line item, let's say you're running short on your concrete restoration, so you pull from the roof, you still would need to go back to the engineer that did the SERS study to make sure that you're back on track because you have an obligation to fully fund.
Right.
That's
Yeah.
really important. If you're going to use money through it in the pool, you
Yeah.
got to have the SERS reserve updated.
Yeah, I think a good rule of thumb is once you do a project, you need to get an update so that the monies expended from the project can be reflected on a go-forward basis for your funding needs. Okay. That's maybe the simplest way to say it. One of the most significant changes on the budget side was that under the previous statute, if the association was proposing a budget that exceeded 115%, or 15% over the prior year, taking which excluded reserves, insurance. They made a couple of tweaks to required reserves as opposed to reasonable reserves. So it no longer says reasonable, it now says required. So you can't have reserves that aren't necessary per statute in that calculation. Under the prior law, owners would have to petition the board to basically cram down a different budget. Now, if the board is proposing a budget that's going to meet this 115% threshold, it has to propose an alternate budget at the same meeting and let the owners vote on that first before it can implement the more, for lack of a better phrase, costly budget. So bear that in mind because, unless you feel absolutely passionate about that, you're creating a lot more work for everybody involved in that budget process. Okay. If you're not sure what gets taken into account for the formula, again, reach out to your legal counsel or CPA to guide you on that. Okay. Financial reporting, the deadline to provide the audit, the annual financial report, depending on what level of reporting you do, was extended from 120 days to 180 days. Also, it allows for providing owners with a copy of the report by mail, hand delivery, or electronically delivered by the internet. So if it's on your website and owners have access to that, that's now considered delivery. And that threshold, as was discussed earlier in the presentation, that threshold is dropped from 150 units or more to, as of January 1, 25 units or more. So that's a significant change. A lot more communities are going to have websites, which, the thinking there is providing more access to information quicker to your owners. The threshold for the approval of lowering the reporting requirement was changed to a majority of the entire membership rather than of a quorum. And an affidavit has to be completed by an officer or director attesting to the distribution of the report to the owners. And that's the kind of affidavit now that's required to be on the website. When you look at the types of affidavits, there's a line that says affidavits required by this section. So any specific affidavit that the statute calls for you to have, like when you mail a notice of special assessment, that's going to need to be one of those records that's on your website.
Steve,
Yeah.
There was just one clarification because
Did we make a mistake?
the SERS is every 10 years.
Oh, is it 10 years?
Is it 10 years for the update? Is that correct?
That
Yeah.
is correct. Yeah.
Sorry about that.
Board and membership meetings. Okay, so one of the more significant changes when it comes to board and membership meetings is now if you're doing video conferencing of your board meetings or membership meetings, you now have to record those meetings, and the recordings have to be kept for 1 year from the meeting date, and you have to have the link to access that recording if you have a website requirement on the website so that the owners can listen to that recording. So that recording is an official record, must be kept for 1 year. Owners attending membership meetings virtually may vote electronically, but you need to have electronic voting in place to do that. Meeting notices must include a physical location. So if you're doing, one of the biggest questions I get is, can we just do a meeting exclusively by video conference or teleconference? And the answer is no. You still have to have a physical location for your board meetings and your membership meetings. Okay. And then obviously the people have to be able to hear both who are in a physical attendance have to be able to hear the people who are attending virtually and vice versa. So you have to make sure your audio visual equipment is set up in a way that, makes for a productive meeting. Okay.
Steve, really quickly, are affidavits acceptable when the manager is signing off of them, or does it have to be signed off on by board members?
So the only one that has to be signed by the board member had to do with the distribution of the annual financial report. The affidavit should be signed by the person who's actually doing the mailing or the posting. Sometimes we have to do two because there's an on-site manager doing the posting, and then there's somebody else actually doing the mailing in the back office. And so it's best that the person who actually performed the function sign the affidavit. is in my opinion. So yeah, your managing agent can sign those affidavits. We talked about this, moving on. So for membership meetings, again, for those of you who are going to have a website requirement that's new, the notice must be sent and posted to the website not less than 14 days prior to the meeting. Different things for an election, but if we're just having a membership meeting, other than for the purpose of electing directors, you have to provide at least 14 days notice of that meeting, and the notice should be posted on the website. And then also for membership meetings, there's a new requirement that at least a quorum of the board of directors must be physically present at the location where owners can attend the meeting in person. So that's important. And then the location has to be within 15 miles of the condominium property or within the same county. So I guess if you're on the county line, you can go 15 miles outside of the county.
The way here is this, right? For board meetings, the board can attend and participate on Zoom as long as there is a physical location somewhere.
And somebody to operate the equipment.
Right. And if you do choose to have virtual meetings like that, you must record them in Condo Land and they must be posted on your website, correct?
Yes.
And then if there's an annual meeting, a majority of the board needs to be present in person.
Correct.
Makes no sense.
We can't figure that one out, but
Right.
I guess they wanted somebody at the meeting to make sure that the meeting was chaired and conducted orderly. I'm not sure why they're mandating a quorum of the board, but that's what it.
So the question here is, what if none of the board members are available physically for a board meeting? Can the manager hold the spot for the physical location?
Yeah. So your manager can be at the physical location and be there to set up, however, if you're doing this by video conference, whatever equipment you need, and operate it and manage the meeting through the video conference platform.
And then there's a question of how should an HOA address the use of AI generated meeting transcripts on Zoom, and do those transcripts become a part of the association's official records?
Okay, so
turn off that function.
Yeah, that function can be deactivated. You don't need to do that. If it's now homeowners associations under 720 do not have a mandatory recording requirement the way they implemented for condos. So you don't need to record your meetings if you're doing it that way. That would be solely voluntary on the part of the association. Yeah, the AI piece that may be built into I would just deactivate that.
And does that apply to cooperatives?
I think so. Yeah, I believe so as well. 719. So official records, the statute amended the list of items that an association must maintain as an official record. We talked about the video conference, audio recording, bank statements and ledgers are now specifically identified, and affidavits, as we just discussed, required by law are part of the official records. Website requirements, all affidavits required by 718. We talked about associations with 25 or more units must post 12 months of meeting minutes and meeting recordings on the website. So obviously you can't post recordings that you don't have, and the requirement to have recordings of hybrid meetings didn't start until July 1, 2025. So moving forward, from that date forward is when you should be have those recordings available. A document must be made available on the website or made available for download through an application on a mobile device within 30 days after the association receives or creates the document. So that's the deadline to get it up on the website. I think that's also in Chapter 720 land as well, because there is a website requirement in 720 if you're 150 homes or more. Parcels is the word, but homes or more. Okay. There's some heightened penalties associated with noncompliance with the official record statute. The level of intent has been updated to reflect willfully and knowingly or intentionally. So that's a pretty high standard that would have to be established. The point of the takeaway from all this is when you get a records request, make sure you timely respond to it. And also, if you don't have, as an association, a formal records inspection policy that's been adopted by the board, I strongly recommend you implement one, and that you do so before you have an owner who's inundating you with request after request, because they can become voluminous. And your managers, if you are have a managed association, their time gets monopolized with some of these what I would refer to as serial requests. Okay. Um, what is this there? Going on? Oh, electronic voting. So there was a significant change to the law to encourage, in my view, associations to implement electronic voting through a platform that's statutory compliant, as you'll see in a minute. Because if you don't have an electronic vote, if you haven't implemented as an association electronic voting, where you're using a vendor to provide a statutory compliant platform, you're going to have to do certain things with your ballot that is another administrative burden. So first of all, to implement electronic voting, it's by board vote. You have to send out a notice to your membership by mail 14 days prior to the meeting. The notice must also be posted where you post notices on the property. So it's mail and post. And now if 25% of the unit owners petition for the implementation of voting, the board has to hold that meeting and essentially implement electronic voting. If electronic voting has not been implemented by the board, then the association has to designate an email address for the receipt of electronically transmitted ballots. So this means rather than owners having to mail back their ballots in the double envelope system that we're so used to, they can email a ballot back to the association and waive their secret ballot. So this is the burdensome part. Now, you have to have set up an email account or an existing account where when you send out the ballots, you have to have this disclaimer, which is at the bottom of the screen, warning owners about the waiving of the secrecy of their ballot. Okay.
Hey,
So
let me just interrupt for a minute, guys. Please don't use the chat for your questions. Please use the Q&A function for your questions, because it's hard to monitor both. And the Q&A is better preserved for everyone to view the answers. So there are a couple of quick questions on there, Steve. Our community has an executive board that meets outside the monthly board meeting. Are these executive board meetings required to be recorded and posted on our website?
it depends on if the executive board consists of less than a quorum of the board, then the answer is no.
When if they're doing business on behalf of the association, there is no executive board.
No. When they say executive board, I think what they're referring to is the officers of the association. And so if you have, a 9-member board and a president, vice president, secretary, and treasurer, that's only 4 out of your 9, and that's not a quorum of the board. So when you have a quorum of the board present discussing association business, then those meetings do have to be noticed and members have an opportunity to attend. So it really depends on what is the number of directors on your board, and what is that executive, what I would refer to as like an executive committee look like.
And then also on top of that, then when they have those meetings of the executive board, they still need to be posted on the website.
It depends again. If they have a quorum, if a quorum of the board is meeting, you can call it whatever you want. It's a meeting of the board. So
yeah,
that's really the determining factor.
Okay, and back to records requests. How should an association handle repeat records requests from the same unit owner when they appear intended to disrupt normal operations or burden the association management or internal conflicts within the board?
Right. Yeah, you need to implement a policy. You need to get with your association legal counsel and implement a formal records inspection policy. There's certain limits that can be placed on how a records request is made, meaning that it be done only by certified mail, return receipt requested as opposed to by email. The number of times that records requests can be made by the same owner in a given period of time can be regulated. And the amount of time dedicated to producing the records at an inspection can also be regulated. And also one of the things we didn't mention, but which is now required, is there's a checklist that has to be generated when you're responding to a records request. And the checklist is supposed to list the documents that were requested and then whether or not those documents were, provided or not provided. And if they were not provided, the reason why they were not provided. And that needs to be completed by the association. There's a place for the owner to sign it. You can't force the owner to sign it, but at a minimum, you've got to generate that checklist. Okay. All right. So getting back to the email process. So if an owner can email a ballot back to the association without using the inner and outer envelopes, the requirements, there has to be a space for the owner to type his or her unit number and a space for the owner's first and last name. This type name functions as a signature, and then the following statement must be included in any emails to owners in capital letters and a font larger than used in the rest of the email when transmitting, a ballot to the owner. Okay.
I have a question to please clarify the timeline notice to approve electronic voting.
Yeah, so to approve electronic voting, the board must provide at least 14 days notice by mail and posting to the owners, okay, of when that meeting is going to take place. The implementation of electronic voting has to be done by a written resolution. So it's not a matter of a motion second approve. You need to have a written resolution prepared by your legal counsel implementing electronic voting. There also needs to be an affidavit signed that reflects compliance with the notice requirements for that meeting. Okay, so essentially, if you're going to implement electronic voting, you need to reach out to your legal counsel to have them prepare the resolution, the consent form that goes along with the whole process, because owners have to consent to vote electronically. So they got to complete a form, put an email address in, sign their name, return that consent form. They have the right in the future to revoke their consent. So you got to have a revocation form. So you need to get your legal counsel involved if you're going to implement electronic voting. The question we used to get was, do we have to amend our bylaws to authorize electronic voting? The answer is no. If your bylaws already authorize electronic voting, then you don't need to have this meeting that we're talking about. But in the absence of it being already implemented through your bylaws, which I've only seen in a handful of cases in newer bylaws, then you have to go through this process. Okay.
I have a couple more. Hold on, I'm just
Sure.
answering one night right now, but I know one of them was if the association has adopted electronic voting, then can you prohibit email ballots?
If you have electronic voting in place, you don't need to permit email ballots. It's only if you don't.
You can direct them to sign up
Right,
and get approved for
right,
the electronic voting,
Right.
correct?
Then they just need to go into e-voting, right? Which is much simpler and by the way, preserves the secrecy as opposed to the other process, which doesn't.
In 2025, electronic voting was approved and a resolution adopted. Do we need to do this every year for the 2026 and
No.
future?
No, it's a one-time implementation.
Awesome. And if someone asks for documents that we have on the website or portal and they are told that they need to go to the portal to get the documents, do we still have to offer them an inspection physically?
No, if the documents can be, the most important thing is making sure that they have a username and password to use the website, but producing the documents through the portal such that they can be downloaded, I believe is compliant with the official records request statute. You can always check with your association counsel, but I believe that's the case. But most importantly is making sure people have access to that website.
And then returning votes by email is not considered to be electronic voting, is it? No.
No. So electronic voting is when you have a vendor who supplies the association with a voting platform. There are a number of companies that do this out there. Catie has a list if you need a referral to several of these companies for you to interview, but you're going to end up entering into a vendor contract with a company that's going to supply you with a voting platform versus the email ballot process, which is waive secrecy. There's more administrative. There's more administrative burden, and there's more opportunity for problems because if you miss an email and a vote doesn't get counted, that can be a problem. If they vote electronically, the platform has to establish a communication with the owner, and it's likely to be a more secure and more reliable process. So from that standpoint, I think again, when I look at this change in the law, it seems to me that they're trying to push people into e-voting.
And then how can we verify that people who are emailing the ballots back, that it's a valid email? Can we not accept them from people that we don't have the email address on file? That's a valid question.
No, it's a legitimate question.
Put Steve Braten at Gmail and get, send
Sure.
your ballot.
Well, the ballot still has to be returned within, and it's even because it's a printed name, it constitutes a signature. So that's a great question. I don't know. I don't know the answer to that.
So
'cause we
just,
haven't had to deal
when
with
this
it.
first came out, I had to do an election in July, right after the law was passed at a contentious condo that also did not have electronic voting implemented. So what we did is, and I'm a state certified election monitor for all of you that are on here. What we did there is we verified it against the unit owner's information on file that the manager had on file.
Mhm.
And if it matched the email address, fine, I accepted it.
Okay.
If it didn't match, I had her actually reach out and contact that owner to make sure that that is their email address and that they did indeed send that email. And there was only one we couldn't verify, didn't have it online. They wouldn't answer, and I did disqualify it because I'm not comfortable accepting something from someone that we don't know that it's a valid email address, which also leads us to why we should have electronic voting adopted.
Yeah, all this goes away.
away.
All this goes away with electronic voting, and I think you're going to find that the cost is not prohibitive. Moving on. So insurance requirements in terms of 718, 111, which is the statute where you'll find the insurance requirements for the association. The association has to carry adequate, what they refer to now as adequate coverage based on replacement costs. The replacement cost must be determined every 3 years by an independent appraiser. The association's obligation to provide adequate insurance coverage, and we're talking about property insurance coverage right now, not general liability but property insurance. For at least 3 or more associations, they give you an opportunity to satisfy it a different way. Most clients don't go about that this way. So again, just make sure you're getting with your agent, that you're doing your insurance appraisal to make sure that the cost, the assets that you're insuring under your property policy have been updated per statute, and that you're insuring at the right levels. If you're looking at deductible changes on your wind coverage, the board should vote on that and stick to what's customary in the industry in terms of what's a reasonable deductible under wind, because recognize that the higher that deductible goes, the more you're self-insured in the event of a loss, which will likely lead to a special assessment. So you have to look at that cost benefit analysis for increasing the deductible. Pre-sale disclosures, sellers, including developers, must provide the most recent approved budget and financial statements to prospective purchasers or lenders that request it. Contracts must include clear statements about inspections and reserve status when we're dealing with a developer-controlled association. And the right to rescind has been increased to 7 days for non-developer sales based on the receipt of this information. So there's been some changes to real estate transactions and disclosures that you may want to be familiar with.
And I think part of the best way to handle that is part of your application package, have a form that says, have you received these items from your seller, the seller, sign here if yes. And that way that puts the onus back on the buyer to agree that they got those things. And if they didn't, they can go back to the realtor or to the seller.
Okay.
Right?
Yeah, no, that's perfect. With regard to, again, CAM and CAM firm contracts, The association has a duty to ensure that the CAM or CAM firm is properly licensed before signing the contract. That's something that can be readily looked up on the department's license verification website. You can always have, I mean, if you're entering into a new management agreement, it's always a good idea to have legal counsel review that. And in that process, you can ask them to verify the license. The association may terminate a contract without penalty if their CAM's license is suspended or revoked during the course of the contract. Again, all CAM and CAM firms must be licensed. With regard to hurricane protection, okay, this one gets interesting. So this is when we're dealing with the association doing concrete or repair projects to the building, and we get into a scenario where hurricane protection has to be removed in the course of the association doing a repair or restoration project. Who's responsible for the cost of removal and reinstallation? So the statute was amended to clarify that unless your documents provide otherwise, then the owner is not responsible for the cost of any removal or reinstallation of hurricane protection, including windows and doors, if the removal is necessary for maintenance, repair, or replacement of other condominium property. So if you're doing a balcony restoration project and you have to take hurricane shutters off of sliding glass doors, the association is responsible for removal and reinstallation, and that cost becomes a common expense unless your declaration says the cost of removal and reinstallation is an owner expense. Okay. Now, one of the question comes up in this process is, okay, we remove the shutter, but the shutter is so old that we can't reinstall it. It's not safe to be reinstalled. It's not code compliant. Whatever the reason, what do you do? Okay. My suggestion is make sure, and yes, it costs more money, but have your engineer do a survey of your building in advance of the project to make a determination of which shutters or which windows, which sliding glass doors are not going to be able to be reinstalled if they have to be removed, so that you can get ahead of the curve and send notice to your owners. We have buildings that are 45, 50 years old that still have original windows and sliding glass doors. Okay. Chances are, if one of those windows and doors has to be pulled, they're not going to go back. You're going to need to install a new window or door. And then that's going to slow the project down. And then we get into, well, does the association have to provide the owner with a brand new window or door because it says we're responsible for reinstallation? I don't think that that's what was intended by the statute. Why would the owner get a brand new window or door if it's 20 years old and they weren't maintaining it properly? And that's assuming the documents require the owner to maintain, repair, and replace their own windows and doors. That may not be the case in every set of documents. So again, as you go into a project that's going to impact the hurricane protection of your building, look at these issues up front, get with association counsel and your engineer so you can plan the project in a way that you're not going to run into delays with the contractor because they're waiting on door deliveries or window deliveries. Okay.
There's been a couple questions about the wind mitigations. It is still every 5 years, right? Unless the carrier requires it more often.
You mean a report?
The wind mitigation
Yeah,
inspection.
I think that's 5 years.
Yeah, and that's when Steve talked about the My Florida Condo pilot program. That is something that they are offering to pay for, with a board approval to get that wind mit done. But remember, I said you guys go to the My Safe Florida Condo pilot program, get on their email list, and when it comes out, it usually comes out end of August, beginning of September on 2026, jump on it right away because they run out of money within a month.
Okay. Also, one of the things that was implemented is a mandatory reporting requirement for condos and co-ops. You have to create, maintain an online department account. Reporting is also required, including the age of the building type, status of Sears. Now, there is a place to upload your Sears report. That's not mandatory. That's, if you want to do that, you can. You're not required to do it. You will be able to navigate the reporting page. This needed to be created by October 1, 2025. If you haven't, you need to get on it. I will tell you this, we ran into a scenario, which is, I think, very rare, where we had a condo project that didn't have a project number for the association. if you run into that problem, reach out to Catie. We have a contact at the department that can assist with getting you a project number if you don't happen to have one. Most community do. This was an old building that was created before the requirement, which is tied to having to pay $4 per door to the department annually. Okay. The board of directors, in terms of emergency powers, has the authority to order an evacuation of the building in the event of emergency. And the association is not liable for any injuries to residents who refuse to abide by the evacuation order, whether it's from the board or a local governmental authority. Okay. Couple of non-residential condo changes beginning July 1, 2025. If you're less than 10 units and you're non-residential, you're exempt from turnover requirements. Members may only cancel developer contracts once they hold 90% of the voting interests. And after July 1, declarations may allow for changes to the unit size, appurtenances, or common elements with owner lien holder approval. So that's usually done during the development stages of the project. Senate Bill 948 has to do with flood disclosures. It requires a landlord of residential property or a mobile home park to disclose make certain disclosures regarding flood risks, past flooding of the property, etc. There's also some disclosures required of developers of condo and cooperatives relating to flood risks and past flooding in the sales and long-term rental agreements. Expanded again, this expanded the flood-related disclosures required under contract law that must be provided to a prospective purchaser of residential property. If you're engaging in the sale of your unit, it's probably a good idea either to get with your broker or an attorney to assist you with the sale and make sure you're complying with all these new disclosures. Timeshare plan management, CAMs and CAM firms managing timeshares are primarily subject to the Timeshare Act, which is 721, rather than the broader CAM regulations. So again, if you're involved with timeshares, the laws are going to be quite a bit different. Timeshares are generally exempt from most of the things we're used to dealing with under 718. What else we got? I'm going to skip administrative procedures. I don't think we really need to. We're going to provide the presentation, right, to everybody who's been registered.
Yes.
So I'm going to jump over some of this stuff. And education and correctional facilities. Okay.
Which is a joke because you can't get your manager's license if you're, I don't know.
Yeah. Well, I guess this
stuff they make us put in the report.
Yeah. So with that, I'm going to come to the end. Thank everybody for their attendance. We appreciate all your great questions.
We really zipped through it. There wasn't a lot for HOAs this year. We have a couple of more questions. There was really nothing.
Yeah.
They gave everybody a break after last year, so it was a short legal update. Does the liability of owners refuse to evacuate, including hurricanes, by local police, does that liability fall back on the condo association?
So if they refuse to evacuate, that's on them. Yeah, it doesn't come back on the association.
Okay, and then there's a couple more questions too about the DBPR online account. So one of them is a condo that says the DBPR can't find their project number.
Right. So email Catie, we'll give you a contact at the DPPR. You may not have a project number. We had to set one up for a client.
And you just need to create a new
account. They'll create an account for you and allow you to do that. And the good news is they didn't make the client go back and pay for the annual door fee for the last 50 years.
That's nice.
So,
but you should have that already.
Yeah, you want to get that project number because there's some other ramifications I'm not going to get into on it, but you definitely want to get that. We can help you with that.
And then for the website requirements, what if the management company has the website created, but not all the records are up there and they're saying they can't find them because of a change in management?
Well, if you're running into a problem with locating records due to a management turnover, then I strongly recommend you get with your association legal counsel, reach out to the past management company, and do your best to get those records from them and then up on the website. I think you have to make a good faith attempt to secure records from a prior managing agent, such as a property management company.
Okay, and then can you talk briefly about House Bill 465, which is supposedly looking to mandate management companies?
Well, yeah, I mean, that certainly could be very expensive. I know that the Community Association Institute's lobbyist is pushing back on that legislation. So, a lot of things get introduced, they don't necessarily make it very far. And hopefully that's one of them that won't, because that'll certainly put an expense on a lot of communities who prefer to be self-managed. And then I haven't read the bill, so I don't know if there's a unit, if there's a unit number tied to that, the way they've done with the website requirement, meaning if you're a certain number of units, you have to have professional property management. That might make sense if the number was reasonable, but certainly not mandated statewide for every community association.
Got it.
Yeah.
And just to clarify, if a committee gets together to select paint colors for the exterior of the buildings and there's not a quorum of the board members, then you do not have a record of minutes or have to give notice to the owners, correct?
If we're talking about a committee in condo land, then I would direct you to 718-112 about the notice requirements for committees. The bylaws have to exempt committees from the notice requirements of the statute in order to avoid, for lack of a better word, the notice requirements, and as well as keeping minutes. So that's really a question that you got to go back to association legal counsel, because it requires a review of the governing documents for your association.
And then there's one more question too about the checklist for records.
Yeah.
So is this something that the unit owner needs to have filled out or the association needs to provide to the unit owner?
Yeah, so I think when you look at the statute, it indicates, or at least our interpretation is that the association needs to provide it to the owner with the response to the records request when you're making those records available for inspection, that you have the checklist there completed, indicating what you're providing, what you're not providing. So for example, you can get a request for records that are considered protected records, meaning not subject to inspection. So you would indicate not provided. If you get a request, for example, for a sales application, lease application, real estate sales contract, any of the information that's exempted, attorney-client privileged information, or letters or communications. So anything that's exempt by statute is not subject to inspection. So you would have to explain that. And then if the records go back beyond the reporting, the retention period, that may be the reason. So it really depends, but yes, I think the association should complete that checklist in an abundance of caution.
And do electronic voting and those that doing mail-in ballots cutoff time be the same cutoff time? Example, electronic voting cutoff date was the day before the cutoff date for the mail-in ballots. Is this okay? I wouldn't say a day before, but
yeah, I think a day before is a bit much.
A couple hours.
I think maybe a couple hours before, because some of these vendors, if your meeting is at 7 o'clock at night and they close, their business hours is 5 p.m. and you may not be able to get the report. So you may need to cut it off at 4 or 4:30 in order to get the actual voting report. Then I think that's reasonable. The day before seems like that's a bit premature.
Yeah, and I mean, I'm a state certified electronic election monitor, no electronic voting monitor, although it falls in the scope. What we do also is good practice is if it's a large association and there's going to be a ton of validation, we actually have me come and we post this notice like 48 hours in advance and come maybe 4 or 5 hours before the start of the meeting to validate the exterior of the envelope. So we're not there all day. And you all can do that too. You would need to post it so that your owners know the ballot box would be opened. And that doesn't preclude you from continuing to accept ballots right up till the time the meeting starts. But it does give you a head start on getting everything verified before the start of the meeting. So you're not there for 5 hours.
Yeah, and that makes sense for very large communities. And the validation process has to be done by the impartial election committee that's been created to also verify the ballots, verify the envelopes, and count the ballots at the actual annual meeting. So just bear that in mind. So that committee needs to be in place if you're going to do that. So if this is a first time for you to do something like that, again, reach out to legal counsel and make sure you're doing it right. So there's no unnecessary and costly election challenge just from a procedural defect. Okay.
Yeah. And I think that's it. There's some questions about the certificates. We're finished. If you need to go, you will go. We will send out the certificates to everybody. I'll get them to you by, let's say, Monday. Vinteum will be working with me to get us the list of the attendees. There is no reporting method at this current time for the board members who have attended, so just retain your certificate as proof that you have attended this class, and that will count towards your continuing education. I think it's coming down the pike that will probably issue some sort of number for you, but there is no reporting method for me at the moment for that. And Vinteum will also be sending out a copy of the recording. And if there's no other questions, thank you guys so much, and we appreciate it. Peggy, did you want to jump back on here?
Yes, I did. Thank you so much. I just want to say thank you to everybody, Steve, Catie for moderating today. And I just want to say to everybody, it has been an absolute pleasure to be able to offer these education classes this year in 2025. Some of you have become longtime supporters now over many years, and I cannot say thank you enough, especially also to Julia. She's been the wind beneath my wings this year in particular, and the backup team, I know there's support there that also helps you too. So I want to wish everybody a very happy holiday season and a wonderful new year, and look for us January right off the bat, January the 9th. We have an outstanding panel presentation with Munyon Painting, one of our sponsors. So it'll be including with Sherwin-Williams. Thank you so much. Happy holidays.
Happy holidays,
Thank
Peggy.
you.
Thanks for having us.
Thank
Appreciate
you.
it. Bye.
Bye-bye.